morning, sir. Sir, my name is Suresh Kumar Singh. I am Superintendent in Narcotics Control Bureau. I think mic will not be required. Not so many gatherings. So, my name is Suresh Kumar Singh. I am Superintendent in Narcotics Control Bureau, Siliguri, serving since last 15 years. I have posted in so many places in across the country. Northeast, I have experience of over 10 years. I have served in Guwahati, Assam. I have served in Manipur, Imphal. Then I have served also in Jharkhand. And now at present I am in Siliguri. The Siliguri jurisdictional area is North Bengal and the entire state of Sikkim. So actually I am very little fright. I am not a teacher like, so who can teach you all learned judges. You know everything, sir. And my just things is there. What I have learned throughout my tenure in Northeast and in tenure as a superintendent in NCB, I am just here to share all those experiences and few of the landmark judgments of Supreme Courts, which are very handful for the prosecution side for securing the conviction. As you all know, the conviction rate not only in Sikkim, in entire country, the conviction rate is very in the downside. You know, I think not more than 20%. Only I have what I have seen in Jharkhand. The conviction rate is there 90% or more in Jharkhand only, but not in other states. I have seen so much conviction rate on the higher side.
What would be the reason?
There are basically definitely there will be a reason. As you all know, NDPS cases. What are the, sir? You know all the difference between the NDPS cases and other IPC cases. In other cases, you also know that you have to prove the commission of the crime. Mainly, you have to seek whether the commission of the crime is proved or not. But in NDPS cases, alongside conviction, you also need to see whether the right procedures have been adopted in doing the investigation or not. That is also very much important, because most of the investigation in NDPS cases are completed at the time of completion of the seizure proceedings. Like you got the secret information, the police officers constituted a team endorsing the secret information to senior officers. A team is constituted, GD entry is made, the team moves to the PO, taking the two independent witnesses, the search, seizure affected, arrest is affected, then the seize articles, taking all the videography, the procedure as per the BNSS 105. Then the seize articles are deposited into the Malkhana. And what happens, most of the investigations are completed at that moment, because once the things have been done, you cannot reverse the events. Means you cannot, most of the events you cannot reverse. Once it is done, it is done. So what happens in the, and this what happened in the next 24 hours, that is a very much limited time, and you have to produce the accused within the 24 hours to the court also. That is one limitation. So you cannot make so many changes in 24 hours. So what you have done in that 24 hours, that becomes the on paper record, and that is the basic reason the most of the mistakes that have been mistakenly done during the seizure part, they cannot be rectified on the later stage. Only what can be done, only the sampling part that is to be done before the magistrate, then taking the chemical report from the FSL, then CDR analysis. All these parts are still remain, but mostly the parts are completed at the time of production of the accused before the magistrate or special court. You all will agree with me. That is the reason you get means the police officers or any other agency get very little chance to rectify the mistakes that have been occurred during the production of the accused. That is the biggest reason you cannot rectify all those mistakes in the later part of the investigation. So the duty of the IO becomes very much fatal in all these proceedings. They have to be very cautious while preparing all the documentation parts, and that is also within the 24 hours. Like very important documents, information note, the first information note, then the constitution of team, GD entry, then main important thing, the search cum seizure list, the Panchnama, then depositing of articles, the seized articles into the godown, taking the receipts, all those, reporting of the search seizure to the immediate superior officers under section 13 NDPS and under section 13 SADA and under section 57 in NDPS Act. So many things you have to, police officers who are making search seizure arrest, they have to be very cautious. In the same time, the accused are to be informed the ground of the arrest under section 47 of BNSS. Then his family members are also to be intimated within the same time frame. So all these works are become very much hectic in the first 24 hours. That is the mainly reason the IO do not get adequate time for preparation of all the documents. So that is the reason, sir, with this I will start my sessions. I have so many things, but let's see how much time allow me to complete all those things in just 3 hours.
Some person, some of the team goes to some other place and some person some other place, but I will be remaining. How come it is authentic that some of the police personnel is not being IA? They can see, so how can it is how you will manage them? I will be the one, everything report has to be IU has to see, IU everything. The consisting team, they are seizing this, some other place, some vehicle, some house, some person. How you
Your very good question you have pointed out, sir. Very good question. Sir, we have also faced this thing. What happens, sir, when, like me, sir, I also constitute the team, my IUs and my team mates move to the PO and do everything. So what happens when you constitute a team of 5 or 6 or 7 persons, including the seizing officers who will act as seizing officer, other assistant officer means sub inspectors or other constables or one person for videography. If you authorize the team and team moves out. Now what we have seen, actually what practical happens you also know, sir. One IO is not liable to do all these things, and it is not possible for him also to do all the things. Like freezing.
Raise this question. Without authority you have seized.
Exactly.
The police constable, how can you say?
Exactly, sir. That is the problem. What happens? All these events like seizing of the testing, seizing, packaging, and preparation of documentations are distributed among the team members. But to avoid that authority part, and during the trial, when the defense asks from the prosecutions, means any IO, this packing, sealing and packing, you have done. So IO definitely says, no, it was done by Mr. X, or who was my team member. So now when question, same way when Mr. X comes into the trial, and when the same question is asked, at that time he may get confused whether I did or it was, because in Panchnama it was, every details are not mentioned, like who made the sealing, who put the stamp or who put the brass seal on the packaging. So to avoid all these legal consequences, it is generally recommended to write all this thing have been done by the IO. To avoid the legal means confusion at the time of the trial. Means sometime the question will be asked from the Mr. Act, he will say no, it was done by Mr. Y. And when it was asked from the Mr. Y, he will say that it was done by the seizing IO. That is the only reason, sir. Otherwise, you also know, sir, practically it is not possible to do all entire things. You know, so many things have to be done during this seizure and seizing proceedings. So it is distributed practically, but on paper it is written that it was done. Testing also it is done by the IU. Only this is the reason, sir. The drug offences are very heinous to the society, as we all know. It cannot be compared with other crimes, because it is not only destroying a few sections of the people, it is destroying the entire society and entire nation even. So it has to be seen on the larger aspects. Why I have just this slide, it is a survey done by AIMS and Ministry of Social Justice and Empowerment. You see where the Sikkim stands in context of the country. It's a ratio of India only, 0.7%. But you see, the Sikkim stands with 5.1, only lagging behind of these three northeastern states. It is the terms of opiate uses, sir. Opiate uses you can see, sir. Sikkim is on the top. The reason is that the state has very low population, and any number, significant number increases, the percentage jumps on rapidly. Like in UP, the population is 23 crores almost. So if a number of 1 lakh is increased, that doesn't affect much on the percentage. But in Sikkim, the population, if it is only 6 lakh, 7 lakh, only 1,000 people, if they add it, the percentage jumps on the higher side. That is the reason also, sir. But this fact cannot be ruled out that Sikkim is having significant numbers of canopy uses also, as per the proportionate of the population proportionate. This is the use of the sedatives, and here also Sikkim stands first. And this is the survey done by the AIMS and the Ministry of Social Justice and Empowerment. Okay, you remove this one. You answer. Okay, next. Just so you might be knowing this data also, sir. So my request is that we need to deal harshly with the criminals, the drug criminals. Basically, we must not deal leniently with those criminals. And my request is that, sir, minor mistakes from the prosecution side, minor mistakes, not means very which is getting affecting adversely to the case. Minor mistakes may be overlooked from the by the which have been done by the prosecutions to secure more conviction. Not for the prosecution side, just to save the small beautiful state of Sikkim. My only the request is that, sir. Address defense. It will not happen, sir. Again, sir, I have taken 2 classes of the Sikkim police, sir. One in Gansu. Yes, sir. Yes, sir. Yes, sir. I hope, sir. And gradually, such classes and such sharing of experience will lead to less mistakes in the paperwork while doing this all. Sir, we all know 21, right to life, right to liberty, right to health, right to healthy life, state protection against state arbitrary action, personal liberty, livelihood. Article 21 provides this all to us. This is 41, we all know, and SADA it is 20. So you need not to explain, all of you know such everything. And legal provisions. 42(1) in NDPS Act and in SADA it is 21. Basically both are same. It is under which we record the information, the secret information, and we submit it to the superior officer for getting his remarks. And few of the judgments are also there where the remarks were not having in the secret information. Means the senior officer was put up the same information note and he only signed on the information note. On the part of his endorsement, he only signed. That is also looked adversely by the Supreme Court in one of the cases, and it was and having some other mistakes also there, several lacunas in the case. It came into acquittal. So I've also suggested in the sessions also that I took in previous 2 sessions to get the remarks of the superior officer that work out the secret information and constitute a team, and action may be taken as per provision of law. Not only his signature, along with his remarks also. So any department, as mentioned in section 42, the officers who have been authorized, you all know, apart from this act, there is authorization of the officers from the internal authorization, like in NCB, sub-inspector and above are authorized. In Sikkim police also sub-inspector and above. In the same way in other departments, the officers have been authorized to act as seizing officer for NDPS cases. When the officers take down the information in writing, they have to send the same information to his immediate superior officer within 72 hours. That is the legal part.
So what is the
Sir,
So what is the main reason for sharing this information to superior officer?
the idea behind this, sir, the seizing officer himself cannot take any decision. He must involve his gazetted officer in the event of effecting such seizure arrest, so that the transparency prevails in the same information. Means there could be misuse of such information. Means if it is not informed to gazetted officers, means you also know, sir, the court believes more on the gazetted officers, on the part of the gazetted officer, and that is why everything, every operations or on event, like in Malkhana in charge, they have also been made a gazetted officers, the Malkhana in charge. On part of this section 30 and 57, they have to report to his immediate superior gazetted officer. So belief is more on gazetted officer. That is why I am to make the transparency in the case. This information must be
Given to the superior.
superior officer, and it is also a procedural part also. Yes.
One question. What do you consider as a defect in investigation? I have seen some of the cases, SHO received the critical information. He proceeded himself and saw since that everything has been done, but without giving any return FIR on formal FIR, you know the formal FIR. Only everything he has done in formal FIR. Then same formal FIR has been treated as an FIR by the prosecution. But you treat it as a technical defect.
There is a
Without the return,
there is
no endorsement. There is no endorsement to the subordinate officer for further investigation. Only the formal FIR, the prosecution of treating as a for FIR. FIR is so much. What is your opinion? It is technical defect.
Of course, the technicality, there is technical defect in the case also. Once he has received the secret information, he must inform to his superior, means SDPO rank officer at least. And sir, one provision is also there. If a gazetted officer himself receives the information,
SHO is a gazette officer.
then he can proceed.
Can proceed,
But still, he has
where is
to.
the FIR now?
He has
Which
to.
document has to be treated as an
Exactly, sir. Exactly. He has to inform his superior officer also. Though he need not to take the permission from him, but he has to intimate the matter, the information to his superior officer. He can proceed, definitely, but after proceeding and affecting, I don't know whether he affected the search seizure arrest.
After everything search is affected, then he mentioned everything fill up in the formal FIR. Then subsequently he has intimated to the superior officer.
Okay,
So
that-
I do not find in a fire endorsement all these things.
What happened then?
Yes, thereafter,
He deposited the seize article himself, or
he has hand over to the subsequent IU.
it's a technical fault, sir?
No document was simply handed over.
He must come to the Thana. He has to make FIR. Then and who will make the FIR?
Proper FIR there.
It is a technical defect. I understand, sir, your position. You also don't want to get the cases, all the cases in acquittal, but it becomes your misery also, or your problem also. What you can do, you cannot unjustify your post, sir. You have to justify, and you cannot do every case as conviction. Of course, there are technical mistakes, and you cannot rectify those mistakes. So I understand your position. Here, he must have done a bit different. He should have informed his senior officers. There must be separate Malkhana in charge.
He said make a GD entry also.
GD
No
entry.
GD entry also.
Because once I have seized, I cannot deposit it and I cannot take the signature of myself only. Na? There must be one separate Malkhana in charge
So
to make it
there
transparent.
is no operating procedure.
Of course, sir, there is operating procedures. There is operating procedures. I know about the NDPS cases. I have very less knowledge about SADA, what is happening about SADA, in SADA here.
Procedure is almost the same.
But what I have gone through in NDPS and SADA, I have seen a very less difference in both the acts. Only difference on the parts of some drugs. Like in NDPS we seize as per the weighment, and in SADA it is done as per the counting of the numbers. Pharmaceutical drugs. Schedule, there is a schedule for that, and the counting of the numbers only, and in NDPS we seize as per the weighment. Only that is the difference I have noticed. There may be more. As I said, I have very little knowledge about SADA. I have practiced this NDPS sector about my career so far. So you pointed out very nice points, sir. Right. So we are just going through this NDPS Act. Okay. So under section 43, there is a provision of conducting searches or arrest in public places. In public place, in 42, under section 42 or section 21 of the NDPS cases, there is also a provision, sir, when somehow the permission or the means it was no scope of time, means the time was not allowing to inform to the superior officer, writing the grounds and the justifications, the officer could himself proceed, but that makes the case bit suspicious also, as per section 103 BNSS or previously 100 of CRPC. There was provision, sir.
I have seen most of the cases.
Sir.
The house search warrant,
Sir.
usually normally is to be given by the
Magistrate.
Now some of the cases even super officer, SPM or DSP level, they can be issued. But without assigning any reason, most of the cases just they will go and conduct the house search even odd hour also. And just because of some of the SHO has given the
Authorization.
authorization. What do you think? This is
Sir, in
effect investigation?
Sir, in 41 subclause 2 and in this SADA 20 subclause 2, there is a provision, sir, without if because search seizure arrest is to be done between sunset and sunrise. Sorry, sunrise and sunset. And now the information is like some trafficking is to be done, or it is supposed to be done in the after sunset and before sunrise. Then there is a provision, the IO take the permission from the gazetted officers of his department. That is in the form of authorization.
Whether there is any designation of officer, SP rank or DSP
No,
rank?
rank is not defined, sir. Any gazetted rank officer.
In SHO also the gazetted officer is 6.
So, if the sub-inspector is going to affect the search seizure, he can take the permission from the SHO.
SHO himself is proceeding for search warrant.
So,
he has to take the permission from the superior officer.
of course, he has to.
I don't know what you say, but reason has to be recorded. Without
Definitely,
warrant of the
sir.
magistrate, the reason has to be recorded for such and such immediate.
Definitely, sir. And this reason must be reflected in the search seizure list also, in the Panchnama also, in the FIR also.
Sikkim, we don't find all this.
Some mistakes are definitely.
That's why every case is going on like this without assigning any reason, just because of the search and seizure have done as part of whole 100 CRPC, all these things. And their reason is only the while coming in the court, because of there is a hurry, there is a charges of departing this thing, destroying this. That would not be sufficient, I believe, for writing the suit. There must be some reason.
We understand, sir. But you'll see in later period of time, I have just gone through. I have also taken classes also. I think I have discussed this thing with the investigating officers also. Things will rectify, sir. Definitely in coming years it will be rectified. So, when gazetted officer himself is proceeding on the search seizure arrest, he need not take to permission. He only needs to intimate his superior officer. He need not to take the permission. But he has to record all the justification in the FIR, in the Panchnama, in everywhere.
Can you provide a relevant provision that he has to intimate to the superior officer before proceeding search and seizure, if any gazetted like a SHO?
Yes, sir. It is there, sir. I will give you, sir, later. Otherwise, we have this also 103. If time is not allowing, we got the secret information like one vehicle, it is coming from Siliguri and it is likely to pass whichever the MG Mart. It is supposed to arrive MG Mart and likely to deliver a consignment of contraband. You have got the information and this has to be acted within half an hour. Otherwise, the delivery will take place and consignment will be lost. So what happens at that time? There is no scope of taking permission from all these. The that can be done without taking the permissions also. But all these justification must be reflected in the FIR, in the search cum seizure list also.
What do you have any suggestion? The chance recovery, police every time they say
No, not every time, sir.
Without assigning reason.
This makes the case.
Chance recovery.
This makes left the case very much in demerit also. It is not to be done. Provision is of course there, but it is to be avoided.
Despite having provision, they make an excuse that this is chance recovery.
Yes, there is a provision also. Chance recovery. Definitely. Videography. Videography, you know, sir, 105 now, after 1st July 2024, all drug-related cases in we are doing videography of the search seizure arrest. Search and seizure basically. We are doing the videography. Sir, you also.
I just have a question with respect to videography.
Yes.
Because I believe this is a very American concept where, they have the resources, so people have the body cam and all. How are you doing it in Siliguri or wherever?
Ma'am, Siliguri, we are at present we are detailing one officer, one constable or any rank of officer with the order sheet. The order sheet means the team movement order. When we prepare the order for the movement of the team, at the same time we authorize the sub-inspector or above rank officer for effecting search seizure arrest, and at the same time we also authorize one constable rank or any head constable rank officers for conducting videography of the
I think that's a very thing, because in Sikkim we just have one or two photographers who are in the payroll of the police, so they are not able to go everywhere. then what happens ultimately is some random, without any assignment, like you said, no duty order and all, one of the team member is taking photo. Ultimately, it all boils down to the section 65 and section 69 BNS's
Yes.
certificate, and that's where, because photograph and videos are sometimes the best evidence.
Exactly.
But the thing is, because of that small technical glitch on the part of the IO and the team, then it becomes...
The entire case is gone. Right, ma'am. Rightly said, ma'am. To avoid all these lacunas and demerits, we have the one and only option that I also prefer, e-Sakshi. E-Sakshi app. If you use e-Sakshi app, you have to register yourself first in the e-Sakshi app. There you need not to take any hash value or any other thing. Once e-Sakshi app, you record the videography or you do the videography from the e-Sakshi app, you need not to authorize any one of the officers. The copy of the same is uploaded at that same time when you keep on the videography. It is simultaneously it is uploaded. You also sort out the video in multiple videos. Like if you want to avoid to make one video at a length, you can do multiple videos. There you need not to take the hash value from their e-Sakshi, because it is authorized app and there is no chance of tampering on the app.
What about the authenticity of the video? You don't need to comply with the section 65 and other evidence, provision of the evidence.
There is a certificate also to be taken out, sir. In that also certificate is to be taken out, but during when you have done the videography from the e-Sakshi, you only write it has been done from the e-Sakshi app. It was done from my mobile, and my details of that mobile number with IMEI has to be.
How to ensure that the video is not tampered or doctored?
Because it is uploaded at the same time.
With time, with date?
With time, date and everything.
Okay.
So,
and e-Sakshi.
yes, sir. That is the reason e-Sakshi, there is very less chance of tampering. Simultaneously, videos are also uploaded on the e-Sakshi, and it can be seen.
You can be the date also. Video can be the.
Then it can only be copied. From there it can be downloaded only.
But it is not what you call it, visible or sound is not proper or all these things. How you take evidence? If they suppose say take the video, subsequently while during the trial,
Yes.
video is not visible or sound is not clear, how to make
So generally this type of situation has not come so far. That during trial, because
so many things are pros and cons. Where the jurisdiction, we have to see that, we have to see each and every situation, every moment, all aspects. We have to see how far it is authenticity, how far it is valid, whether it can be only blindly can be considered as evidence.
No.
It should be seen.
definitely videography cannot be directly taken as evidence. Evidence will remain same. Your search Caesar list, the first information note, the godown receipt, the chemical report. Those are the only evidences. This is only the procedural, how you have proceeded, and this only shows the procedural things what you have done during the search Caesar arrest. This is not directly as a evidence. Sir, it's very new, sir. You will see in the later stage, sir. Because e-Sakshi, I think it has come into operation, I think, in February, March only. February, I think. January or February. It was there. After, I think, it was in September 2024, but it was not being used. Definitely, sir. Sir, now Sikkim police are doing good, sir. They are undergoing training also.
So bad. I have to equip them, despite the heavy seizing of the commercial quantity. I have to seize. As of now I am considering since 1 year, my conviction is 0. I dispose of the cases more than 94.
All are in acquittal.
All acquittal.
We can't help it sometimes, because when the case comes to us, it is so beyond repair. Like you said, that 24-hour window, everything goes bad in that.
As of now, my service going
Yeah, understand.
And we know that it should be a conviction, but we're so
I can count it, how many I have convicted, sometimes 4, 5, more than 4 or 5, at least in 4, 5, convicted, rest all acquitted.
Sir, they are undergoing training. I've also, as I said, 2 sessions I have taken in Gangtok, in Namchi, and some effect will be seen, sir, in later stage of, I think. Because I've also noticed what they are doing mistakenly, doing wrong in their seizure list, and what I have just meant them to make it correct. I have just also requested to do this way. So effects will be seen, sir, but it will take bit time, sir. And you see, this is mandatory.
Eventually, when this, they arrange that most circumstances are in possession of the
In position may be of various kinds, sir.
yes, yes.
Physical conscious position, position with the bag, position in the vehicle, because vehicle was in his position, so it is in position of the accused. So how do you see, means when it becomes mandatory to this, we have to do this, there's a compliance activity. When do you see that it has to be done, no other way? Like I'll show you, I have got some important judgments also Supreme Court. Where you will see it becomes not mandatory for section 50.
Prior intention.
Yes. No, prior 50 is personal search. Compliance of personal search. Where it becomes very mandatory, you have to comply. There is no other option.
Sometimes one also says symbolic position also, but they may concept physical position is conscious position.
Exclusively when it is about your body search. Exclusively. Means what I have just put on my body. My jacket, my no, not for back. Not for back, sir. Supreme Court has clarified this thing. I will show you judgment on this. I have judgment. It is not sir, not required. Bag can be taken apart from the body.
Back also comes that
Of judgment of please cite.
the part of judgment, the bag was there.
Because in one of the judgment I had also seen that lady's purse, when it is clinging with her body, it should be taken in the part of the personal search also. Sometime.
Yes, that's why
It's a factual.
any boys or girls, whatever they are really
Yes.
attached with the body, it should be but as a part of the body.
But in personal search, the definition of what Supreme Court has laid down, it has clearly mentioned the part of the body. Means your this if you have blazer, shirt, handkerchief, wallet inside the pockets, shoes, socks, even inside the body. Like these days, what is happening? Traffickers are trafficking the drug, consuming the drug in the body parts. They are making small pellets, and they ingest it, the pellets, and later on through toilet they excrete the pellets. And this way they traffic from one place to another. Cocaine from Nigeria to India and heroin pellets also. So many seizures have been reported of that. So these all will be taken under the purview of the section 50 of the personal search.
So it's section 50.
Sir.
So when these accused chooses to search their body before gazetted, herein I have seen the police officer, they are making requisition to the gazetted officer. Section 50 and 24 says they are to take to their place. So how you interpret this?
Sir, what is the basic idea behind this? The search must be conducted before a gazetted officer.
Yes.
Whether you take the accused to the
No, in section language is said.
language is rightly said.
Before the gazetted officer.
Before
They are
the
making
gazetted
requisition and they are coming to place. How they can be making it convenience of the gazetted officer? There is a legislature especially mentioned take to their place.
Sir, in Arif Khan versus State of Uttarakhand, 2018 case, you might be knowing about that. it is exclusively on the part of section 50 on the basis of the non-compliance, proper compliance of, means it was not compliant there. Due to non-compliance of section 50 and other also some factors of there are also there. Supreme Court acquitted Arif Khan in that case also. In that case also, Supreme Court has not mentioned that accused must be taken to, suspect must be taken to the gazetted officer.
I'm not saying. The section is saying married.
Many. Yes, sir, I have gone through. It is written.
They are saying that they should take accused before the gazetted officer. Gazetted officer should not come before them.
Take such person without unnecessary.
Without unnecessarily delay. Yeah, I have gone through, sir. Section 50 it is.
So if we comply with section 50 in this particular language, then how they manage to take amnesty? There is a specific PO. The moment we implement this, the PO will be changed. How they manage this? IOPs.
Sir, I don't know whether this type of incidents have reported in your court or not.
No. We have to integrate the problem.
Exactly, sir.
We are making requisition.
Law is clear, sir.
There is no problem to make requisition to get it officer.
Law is clear.
Law is clear.
Yes, sir.
So they have to take what when they have identified one PO. So while complying section 50, how they manage, because there will be another PO now.
Yes.
So how they will cope up this provision without now these
To avoid
yes.
any adverse legal consequences, we must do what it is written in the act. First of all, we must go through what it has been reflected in the act, because law is clear. It is written, take the accused to the nearest gazetted officer. Nearest. Now the interpretation will be like this. It will be asked by the defense counsel. The nearest gazetted officer was there or some other department. Why it was not taken to them then? Then this interpretation can also lead to some other points also. Because if I am from NCB, I have a search seizure at a PO, and now I have to comply section 50. What I'll do? I'll take them to my gazetted officer definitely, because I have all this thing. I am reporting to him all the incidents. I have come with his permission also.
Here also we have gone through that. So police officer for their convenience taking this accused person at their option to treating police officer as a gazetted officer.
Exactly.
Whenever I could see no, police can't be gazetted officer. Because the moment you choose police officer as a gazetted officer, then the impartiality you cannot make. There is a judgment of Justice Meenakshi. So the moment
Supreme Court,
High Court, that is binding to us. So therefore, the gazetted officer interpretation given by our High Court is not police officer, either DSP, SP or DIG. You have to choose independent gazetted officer. One thing, there is another. The second thing is section 50 says you have to take to the before the gazetted officer means how they correspondence. Sooner there in the position of the accused. How they make requisition. What is the procedure? Is there any SOP?
for making requisition.
Making requisition, what is the procedure? How much choice could be there in the hand of the IO case? How much choice now the IO, how to determine this? Suppose now there is gazetted officer, NDCP has GM video in our state. They have reservation to stay as a gazetted officer. It's made out in 9.9.
I don't take this. Actually, I don't take this. I'm paid over
Can I just say one thing?
Yes, ma'am.
This produce search paper gazetted officer. Most of the IOs in Sikkim follow this trend of calling the gazetted officer without moving the accused. Simply because if the accused is staying in suppose in MG market and the gazetted officer is down. So the difference they notice is that in the way, along the way, first plan.
Contraband has been planted.
So that's why this was very right in saying that it has First we take into the gas possibilities.
acquittal in our department, sir. Not a single case. One acquittal came in one case where the contraband was not recovered from the possession and we could not prove 29 criminal conspiracy. Not only acquittal that we faced, it was due to not proving of 29 because at that time, I think it is a matter of 2019, I think. The call detail record, this thing we could not justify all this. Only the acquittal we faced. Otherwise, we all got conviction. All conviction. So what we used to do, we always call the gazetted officers on the PO. We always used to call. That you said, na ma'am, once you are taking the accused to nearest gazetted officer, and now the accused will take the plea that I was taken from that place to that place, and it was asked from the IO how distant it is. He will say it's a 3 or 4 kilometers. So can you rule out the possibility of not planting of contraband in his bag that you later on from the bag it was recovered? So to avoid all this, we call the gazetted officers on the spot.
No provision to call.
I understand, sir. It is written on the, but in Supreme Court also we haven't.
Court not interpreting this particular point.
Sir, Supreme
Whether gazetted officer now will remain there, it is the eye of the choice of the eye of the case or the choice of the accused. What is the exact position as per the provision of section?
Right, sir. Law it is written like that. But in Supreme Court, it is also not stopping you to take the police officer as gazetted officer also.
Law is there is
Doesn't bound you. You cannot take the officer of your own department.
Supreme Court says that
There is no
police
such.
as a gazetted officer is
Yes.
not allowed.
Oh, he has mentioned the department, not only police. Whatever the department it mentioned under section 42, you can take, or under section 41, you can take. Police, state excise, drug controller, if they are authorized in the state. Any paramilitary forces even, in central paramilitary forces like BSF, SSB, RPF also, Indian Coast Guard, can be taken anywhere. They have not bounded to, not to of the of police officers. So Supreme Court is not bounding of that also.
No, the Supreme Court not decided on that particular point because the moment I was not discussing. Judicial officer Jharkhand and Uttarakhand, they were discussing and appreciating this judgment. Yes, right implementation has come.
Yes.
But Supreme Court has not now, this judgment has been challenged. So they are now appreciating. so to maintain the impartiality, the judgment has come. I was not in fact with all respect aware of this particular thing. They were discussing in National Judicial Act.
Yes, sir.
So now to our healthy practice only I now this.
So what you are doing, sir? Just one point.
No, that is fine to us.
So you are.
No, there are the moment police officer is there. I think I will see definitely more probability plans to convince the case of the prosecution is there or not. See,
Mere ground of this cannot be the only ground.
yes, yes.
Understand. Right. So the points remain the same. Whether we should go with the act. Ma'am, I don't drink tea. Thank you so much.
Black coffee?
No, ma'am, I don't drink. I'll take water and I'll try to accommodate.
Yes, sir.
So the points remain same. Whether we should follow the act or we must act as per the instructions.
In our section 24 they will also suppose GHT is not there and the magistrate is not there. Then police has option to make recovery as per the provision of the CRPC. 102. They can go for this.
Exactly.
Citing the reason in their CD, in spite of now providing an opportunity to comply with section 5024, Gazette officer is not able to, neither magistrate, the location of our
Proper justification.
So we are proceeding and opting the provision of the CRPC. That option is there in the SADA.
Sir, the same kind of option we also used to avail, sir. But after this Arif Khan judgment, it has made everything clear about section 50. You have to take the, you have to give the option of the searching before magistrate or a gazetted officer to the suspect. Means-
SADA is now required to be amended.
Yes.
Oh.
One more thing added there, if the accused is in consent that the police party can take the search,
Oh.
even though the police officer has to take the officer to the gazetted officer.
How to obtain the consent of the accused?
Exactly.
Because there is no unanimity I have seen so far.
In Arif Khan case, there is a procedure also laid down.
Yes.
What you have to give? You have to give. It is clearly written when the suspect is intercepted. The first and foremost thing you have to do, you have to, after introduction and all this thing, you have to give him the straight away the option. It is, we have secret information that you are carrying some contraband in your personal body part, and hence you have the option to get your personal search conducted before a magistrate or gazetted officer. So kindly intimate us your convenience or your option, your choice or option.
Now how the accused will now?
He will write there.
No, suppose some educated are uneducated.
Yes. Then on behalf of him, 2 witnesses have to be taken who will write one of the witnesses from them.
That is problematic.
What happens?
That is very problematic.
Because if the accused or the suspect is illiterate, how can he write?
Question for the prosecution will be, Acha, what was written by you, read out to you? Yes. Or sometimes they say no, right?
Most of the time they say no.
This is written in English.
Yes.
This is written in English. Suppose now we have one Bangla speaking, no English person. Police here don't know Bangla.
Exactly. So, ma'am, the way out is like in justification in the Panchnama or the what I have also noticed, ma'am. I don't know whether you have noticed or not. The police here not making Panchnama also. They are not making Panchnama. The 1-page Caesar memo.
Exactly. They don't know about Panchnama.
I have just asked them in these 2 training sessions to prepare Panchnama. Not write the word Panchnama. You write the part search cum Caesar list. I have given him the specimen of the search Caesar list also what we prepare. The search Caesar list, the first page will be the search Caesar memo, and from the second page they will start the whole story.
Search memo. The search memo is the Panchnama.
No, but that is wrong.
They've been doing this.
I have just made this to correct. I will see. Let's see. They will do it in coming days. So there we mention everything, ma'am, in Panchnama. That it is also a part of search cum Caesar list. So it cannot be disputed. There we clearly mention the accused was given the option to be searched before a magistrate or a gazetted officer in the form of a notice of section 50. We have prepared a notice also of section 50.
What is the role of gazetted officer? Simply they are now coming and signing in Caesar memo.
Most of the time,
So
yes.
is it the proper procedure or what kind of contribution they are required to tender while now implementing section 50?
Once the gazetted officer is called on, he comes, he firstly gives his introduction to the suspect and briefly explains about the incidents. The first and foremost thing he has to do, and this also should be reflected in the Panchnama.
No, this kind of see. Gazetted officer simply they will get requisition. So there is no room for explaining the background of the case. Simply the I will make him to stand there, and in his presence I will provide option. Then the accused will choose the options, and there is a proper format they have to make so far. And they will write, मैं गेजेट ऑफिसर का सामने Then the gazette officer will simply sign the Caesar memo. So this is the
One line should be written by the gazetted. Search was conducted before me.
no, nothing is
That should be reflected.
But what is the role of gazette officer mentioned in this NDPS or SADA?
The whole,
Is there any SOP or rules is mentioned regarding his contribution to implement the section 50?
his contribution is only the part of the search search and seizure for
No,
compliance of section.
written any is written document with statutory provision saying that this is your role. Therefore, it's very difficult to get.
No, in our
Yes.
what we say compendium, it is written like this.
No, I have not seen so
Manuals
much.
also.
Manual maybe I think they have noticed the contents of the manual.
We
They
have
are not
manual.
able to convince to the gazette official what is your role. Simply they are requesting sir एक मिला है कंट्रोवर्सी दुकान से आना पड़ेगा.
For the compliance of section 15, it must be
They will come and they'll just stand there. And the moment
Search is conducted.
moment the defense counsel questioned to him, he was nothing. So
No, he must he must say that.
that obviously that would place suspicion in the mind of the court.
He must say that yes, because many of time I have also stood on the dock and gave my deposition, where I was asked, how did you get the information? Then I said, over phone my IO told me that some contraband substance might be carried by the person, so you need to come to for the compliance of section 50. Thereafter I visited on the PO, I asked the introduction of the accused, then I gave my introduction and I just asked, you have a right to search, get your search conducted. He has
So we'll ask regarding the choice of the officer.
IU
In
will ask.
presence of gazette officer.
No, not in presence. In the notice also. The notice which has been delivered to the suspect, that I have a format of notice also, that it is a legal right that your information that you are carrying some contraband item and your personal search is required to be conducted before a magistrate or gazetted officer. Please give us your option in writing. There he writes, I may be searched before a magistrate or a gazetted officer, whatever he chooses to do. Thereafter, I have been called. IO calls me that he is asking for gazetted officers to get his personal search done. Then I visit on the PO and I take the introduction, I brief the incident and now I ask, so you are comfortable to get your search done before me? Then, and this thing all will be reflected in the Panchnama, the search consider list.
They will not take anything.
That is the problem now.
So
Whatever you do, there must be proper justification of that. Ki why have you done this? Why have you done this? What led you to do this?
It's not. I think it's not.
Actually, why they are not making, sir, you know, they are not making the Panchnama even. Only one page search seizure recovery memo. I have just asked them this time to prepare proper search cum seizure list in 3 or 4 pages, whatever it takes. Not only the recovery memo. Because once the recovery memo is completed, there is very less chance to reflect all these events. Where it will be reflected? There is only one document, then FIR. So in FIR they don't reflect all these things. That makes the problem. So, sir, section 52A,
It's very also dangerous.
but it is very useful also,
So
sir.
very dangerous with all respect. Actually, they all question.
Dangerous to big
Dangerous in
sense,
the
sir.
sense now. This will confine. This will.
This is
determine-
for you officers. You just
No.
say.
This particular provision is if this provision is not complied, then there is no question of now taking consideration of primary evidence.
Why they are not complying? It is a mandatory provision.
No, comply is simply I of the case will submit an application to the magistrate saying that they have already done segregation at Thana. So to comply, just I am seeking permission to send it to the RFSR. And magistrate knows nothing about how to prepare certification, how to videograph, how to prepare inventory, with all respect. I have seen many cases. So reason is not intentionally, but what is the procedure? What is the proper procedure to comply 52, section 52 and section 26A, something. So if you kindly highlight on this particular purpose.
Exactly, sir. Sir, it's very simple, sir.
Yeah.
Ma'am, this is page number 210.
Yes, the rule 8.
It is clearly written how, in which format you have to apply There is no other, you have not to take your mind, only this format you have to apply. And the format of the certified inventory is also there
Yes.
in form number 4.
Oh, yes. So,
It
yes,
is-
record your ruling.
Yes.
So which ruling?
This one is narcotic drugs and psychotropic substance
Ruling just try to
Page number 1.
210.
There is a permit. There is a permit and they have.
We follow this one only, sir.
This is the form.
Yeah, they do it. They
No, no.
treat this as the functional.
No, this is-
This is not, no, remember, this is the procedure of certification of the contraband items.
Yes.
And form number 5 is the application, ma'am. Form number 5 by which the IO submit the application to the learned magistrate for getting the certification done. Form 5 is the, that is why I've asked to call both of you. I just learned that to judicial
No, this
magistrate.
LEC.
That is why.
So when you apply for section 52A, this particular provision says that you have to produce this seized item before the magistrate.
Exactly.
So what we are doing is, they will segregate themselves at Thana.
Themselves means police
I of
officer.
the case. This particular provision of law says HSO sometimes, HSO. In SADA says HSO will submit an application.
HSO, sir.
As Station House
Acha,
Officer.
SHO. SHO.
Station House Officer will
OC.
submit an application, not I of the case.
OC.
In SADA. So OC will submit an application to the magistrate. That particular contraband substances now remain with the position of the I of the case. And what time they will produce and how to segregate, what is the proper procedure to segregate, whether they will call the same seizure witness at the time of now segregating between the magistrate or not, will videograph, so what provision of videography is required to be complied with. Another is the format of the certificate. After convincing the procedure, magistrate is required to provide certificate. So the separate certificate I have seen in the Summit State, Delhi, in Chandigarh. But hearing the format now, whether this exactly this format will now apply to SADA, so these are required to be clarified. So that they can comply very nicely without any reservation, hesitation. The moment they are HSO approach them for implementation of this provision.
SADA is there. SADA doesn't have.
Is there a different format?
License लगाएर मात्रै छ।
License, only for license.
It's not like that. Ma'am, I don't think there is another kind of format given in SADA. The same format which is under NDPS, it is also being exercised in SADA also, because since there is no separate format is given. So, sir, in this form 4, there is 2 criteria, sir. First, we have to understand what is the basic idea of this. It is not new, sir. In the first amendment in 1988 in NDPS Act, this 52A was added. Okay. Now, after the Mohanlal judgment, Union of India versus Mohanlal, I am talking about that Mohanlal, 2015-16. It was a very landmark judgment regarding sampling, storage, disposal by Mohanlal in the Supreme Court. In that judgment, it was directed to central government to make rules, a special provision for pre-trial disposal of the seized article, seized contraband, whether it is drug or conveyance.
Yes, Monal basically talks about how to dispose.
Exactly. Disposal and sampling procedure also laid down.
Yes.
So now this used to be followed before Mohanlal,
Right.
but what changes came after Mohanlal? 2 things. So in SADA, where it was written, the SHO has to produce. It is also not wrong, sir, because it is being talked about before the Mohanlal judgment. At that time, what used to happen, being Malkhana in charge, we have to produce the same before the learned judicial magistrate for certification, sampling and photography, videography of all these things, for complete procedure of 52A. We used to do. But after this Mohanlal, because at that time the sampling part was not being done on before the magistrate. The sampling of the seized contraband was taken on the spot at the PO, and then it was sent without the consent of the, means only the forwarding of the magistrate was required at that time, not the sampling part was done in presence of the magistrate before Mohanlal judgment. That is why it was mentioned there the OC has to produce, because at that time we used to produce, because it was used to be in our custody. We used to be the, like me is the Malkana in charge, so it becomes my duty to get the contraband disposed as early as possible. So it becomes my duty to produce. Now also in the previous cases where this sampling part was not conducted before the presence of the magistrate, means the cases before 2018, we are doing the same thing. But the cases which are being affected after 23rd December 2022, when this GSR 899E came into effect. GSR 899E came into effect. It is a copy also here. Thereafter, the IO himself produces the contraband before the landed magistrate. Now the sampling is done, and then the sampling is forwarded to RFSL or CRCL as per the
There was a
rules.
standing order. Standing order is also interpreted in some
Exactly.
saying that you are not required to comply with standing order because there is a provision in statute.
899E is
Yes,
also
yes.
written there.
Yes, yes.
899 is made by the central government
Yes, yes, central
on the direction of this Mohanlal judgment.
Oh, yes, yes, yes.
Yes, ma'am.
I've been a magistrate for in the course of my, I've seen how Mohanlal is affected sampling. Because before Mohanlal, sampling used to be done, like you said, at the PO and thing. So that time, most of the time, the defense used to be like, okay, there is like say 100 tablets, you've taken out 2, and then 90 you retain, the 90 you sent to. Now what is the guarantee that the 19 is the same as the 2? This was a very common question. Okay. Now what the Sikkim police is doing, because of that fear,
They are sending entire to RFSL.
I mean, I have, as a magistrate,
That is not the
there was
situation.
one bori of
I have-
drugs, capsules, and we wanted to send the entire thing to the thing. And now they are new magistrates. Last time they went to RFSL, the RFSL people are complaining, why is the I sending the entire bunch? But it's because of that question.
Actually, the same complaint from the RFSL people made before me also, ma'am.
So what is the solution?
The solution is, we cannot do, actually sending the entire contraband is not a solution, ma'am. Because RFSL has not a malkhana, na. They cannot keep the entire contraband item in their limited space.
And now even the credibility of the magistrate is questioned, you know.
So, ma'am, my just
No, there is a question of
clarity.
standing entire because this says
Important also, sir.
52 C says
You know,
allowing to draw representative samples, not entire.
Exactly.
What is the question of sending entire? Then what is the
Why are they sending entire? But that is my question.
I was like,
What I
yeah,
said,
it's going to be-
RFSL is not having any malkhana type of things. They cannot keep the entire contract. Let's suppose if thousands of kilo ganja have been seized, then what will happen? In last case, ma'am, in August
I think there
2020,
were about 5,000 tablets in that entire body.
ma'am, you are talking about 5,000 tablet in Guwahati. I was there. We seized 4,600 kilo of ganja. This much room was completely filled in.
then how to send entire?
4,000. How? We never send the entire. We only get the sampling done before the magistrate. Sampling part was done, photography done, videography is done. Mainly we do photography. Videography is not provision under 22. Videography is there in 26.
So then my question is,
Ma'am.
what is the relevance of the magistrate as a witness for the prosecution at that particular?
Relevance.
For that particular separation of something?
That has to be a question.
No, relevancy says now the message like 164 CRBC. Now, this legislative what you propose, the message is completely completed process. Whom the special court can rely. Because this is primary evidence. Now, if this particular provision is not implemented, even if after compliance of section 50, court will not take into consideration any one of the evidence. So this is only
Primary
section- Yes, primary evidence can be now rely on the conduct of the message.
Ma'am,
Most of the time
what I have seen also, ma'am.
Constitutionally, sir, they drop the magistrate.
No.
I said, why?
So ma'am is also right. What I am
Why
just
to drop the message?
in what I told you earlier, ma'am, I have served in Manipur also. There they didn't used to call magistrate. Once magistrate has given the certificate, that's all, and it has been exhibited.
There is judgment of the Honorable Supreme Court. Even on 161, they should not call
Okay.
because there is a provision in CRPC said court can rely without calling them. Until and until they disputed. In BNS system, there is no question of until and until they dispute, even doctor cannot be called.
But in Assam, in West Bengal, in Jharkhand, they are calling magistrate also
So at
for
our
evidence.
case, we don't go to the spot. They bring it to the
Sometimes
court.
they say when you try to go, yes.
So they bring it to the court, like we do it in the court. Yeah.
No, but the law says it's not necessary.
Another
Yes.
really, so far as there are positive under acceptance also. After some incidents, depositing the malcontents and the positive. It is in the malcontent, it is nowhere written or like any entry. While are you taking the entire thing or the sampling for the patient? Now this question is raising by the defendant. I believe they have to maintain all the people malkhana also while taking and giving also.
Sir, in Mohanlal judgment, it is clearly mentioned. If you might have gone through also, there must be separate malkhana for NDPS item. We cannot mix other things with the NDPS items.
There is no space.
But the
There is no
provision is
form of
there. But law is saying like that, sir. I know, but their Mohanlal judgment, Supreme Court has also pointed out to keep one separate malkhana for a district, not for the entire police station. No, not for a separate police station.
In the court.
In one district, there will be one malkhana where all the
Where is
citizens.
the police test to weapon?
But in Mohanlal judgment, it is clearly mentioned, ma'am.
It's in
There
the-
must be one malkhana in a district.
No, I think they've made some now.
So the malkhana of that
So
particular
they have
state,
made, okay, also
particular
DC office put out.
standard.
So,
Let me see, the moment, so if you visit malkhana,
I so now it is.
now with all respect, that particular malkhana is not place to keep contraband substances, with all respect.
One has-
Then-
one has-
पुलिस के टेंट जाऊँ तो मैं करना
Like
खाना के
Goda,
बच्चे आउट
DSP,
Goda.
Sir, थाना में से इनकी.
now they have converted into like
मेरा खाना में बुझाया पंच
I think
एज अ पूरा
Then
बड़ा
what
केस
comes
केस आई सेड दैट 21 केस उसको ठीक होता है
those videos
One case
sometimes you
is
find
cheaper.
damn room. Sometimes you find
The
Yeah.
temperature
washroom
is
is
yes.
behind washroom. तो कहाँ है मालखाना? देखो इधर है, उसी पे सो रहा है, सर ऐसे हो क्या?
No, that must not be, sir. Actually, if you visit our malkhana in NCB Siliguri, we have made it as proper as per the guidelines of the Mohanlal
So
judgment.
you're talking about pre-submission of charge sheet or after?
What
Pre-
ma'am?
pre-submitting
Like
charges.
pre-submission of charge sheet
Yes,
or
ma'am.
after?
Pre.
No, no,
I'm talking about sir. Because nowadays when I do the cases, I know that they are like for sampling, they get it from DC officer. Can you research? And they have made it proper register.
टेंजिंग चाहिँ एसपी छोरा चाहिँ आई थिंक कुड हैव मैनेज होला अरु डिस्ट्रिक्ट छैन
SP, you're there.
No, no, malkhana can be under the control of the SP or court.
Malkhana in charge. And whosoever can be made the malkhana, but not below the gazetted
We
officer.
have separate.
Yes,
No,
no,
no, malkhana is
like I'm gazetted officer, I am in charge of my
No,
malkhana.
no.
Oh, in our case, constable is the malkhana.
No, it cannot happen.
I'm sure.
Constable come and
I am
I am the
talking about the
malkhana.
location.
So because
No,
normally
location. Whether it should be under the control, infrastructure should be under the control of the district collector or control of
SP
the
sir,
court.
SP.
No, it is not written the SP or district collector. It is not written. No,
Under
yes.
the malkhana is under the gazetted officer.
But it is written only the gazetted officer should be the in charge of malkhana.
Where is
In
that?
NDPS.
Where is that?
I'm talking about only of NDPS.
Where is it?
And SADA may be like this provision would be there.
No, SADA silent means all.
Everything.
Following NDPS. Wherever SADA is silent, it means it will follow NDPS.
So this separate malkhana doesn't apply to post charge sheet.
Ma'am, it is
I
Mohanlal.
mean courts.
Like what happened, it was reported, if Mohanlal judgment is a very vast judgment which we have gone through, it has been reported from various state police that this much quantity of contraband has been pilferaged, lost, decayed. Keeping all these aspects in view, the finally the Supreme Court raised on this point that there must be a separate malkhana for NDPS item, because what happened before that, police other articles along with the other articles, the contraband items under NDPS Act, they are also mixing together and keeping in same malkhana. That used to be very difficult in segregating the NDPS item and the other items, and also the chances of pilferage, decaying of the contraband item also became high at that time. So the DSR double line. This one. There is a procedure also laid down how after getting the contraband in the malkhana in charge proceed for disposal of the item. You will be appreciating, ma'am, in NCB cases there is no contraband item produced before the during the trial before the court. No contraband item, because before reaching to the trial we dispose all the items, and this makes our case also intact, airtight intact. Not SADA. SADA is also following the NDPS about disposal.
Like in forest case, there is a huge number.
The forest is also. I understand.
So we'll, as a study, as a GPS, we'll take photograph or and it will be disposed of from time. Disposal everything, all documents.
In one of my session, ma'am, in Gangtok, one of the public prosecutor asked me one question. He said, when we go for the trial and contraband items are produced before the IO, the defense starts creating so many questions on the contraband. How it is torn, the seal is not visible, the weight looks very less now, it was this much and this looks very less, and it has been torn from many places. So what is your best answer? How this problem can be tackled? So what I said, I just told them, we don't take the contraband item before the trial, because once the case is booked, it takes, if it is a commercial quantity case, takes 180 days gives the time to complete the investigation, and thereafter also it takes 6 or 7 another months the case to come on trial. Before that, you proceed for the pre-trial disposal and dispose of all the contraband items, like we are doing in our cases. We can't take the items before the court. We only take the representative samples, the photographs certified and the inventory certified. These things we take before the court, and now you जितना क्वेश्चन पूछना है आप पूछ लो, आपके पास यही 3 items हैं.
This is now your defense.
You have now this given the figure 180 days. So that 180 days is applicable to SADA also. The SADA is silent.
Sir, I have to check this out, because what I said, very little knowledge about SADA. I have never practiced SADA in
SADA
my.
is silent regarding 180 days of filing charge sheet.
So as per 36A1D, NDPS Act 36A1D, it says about 180 days for commercial quantity case, where the punishment is minimum punishment is 7 years or more.
No, there was a discussion about this particular issue. The council now, what the council said is, sir, this is not civil. NDPS is talking about 160 days time to file charge sheet.
180 days.
So SADA is silent, means we have to presume this, that is 90 days. Commercial quantity 90 days. What is the reason I say? Sir, this principle, like in civil suit, that is not applicable in criminal matter. There is going on no decision of now, providing 180 days in SADA matter, even in commercial quantity. That is correct.
Sir, in SADA also, I was just going through, it is written somewhere, if there is any dispute regarding any provision, the NDPS Act must be referred. It is also written somewhere in SADA. अगर किसी में कहीं dispute है तो आप NDPS Act को as a guardian act, central act, you must follow the NDPS Act. So if we have any dispute over, if it is not clearly mentioned how much time we'll get for completing the completion of investigation under SADA. We must follow the NDPS Act. It is written clearly about it.
NDPS is appeal.
If it is not clearly mentioned.
Not clearly mentioned. SADA is not.
Exactly.
Things are just copied on it, without respect, by Mr. PKS. We get no secretary.
I have amended also.
Oh, yes,
I
he was
am
not
a secretary. So I have tried to amend for a very but
So
while
this-
meeting all the politicians, all the big officers, they are
So-
make havoc while meeting. So I could amend elaborately.
So the reason for now this discussing this on 80 days is they are coming in default pay.
Exactly.
Default pay. And now Messi are being confused. They thought 90 days. And they will reflect the order saying that why you have not filed charge sheet. You very silently smile and look at the magistrate. So you look to the officer. It drops, it's 180 days. But I'm saying they reflect it also.
If it is commercial quantity.
On commercial quantity, 180 days.
If it is less than commercial, then 90 days or 60 days, whatever it is here.
So therefore, to clear this particular concept, always drugs matter, commercial quantity, there is no question of considering 90 days. This 80 days which central law is
Exactly,
coming
sir.
for.
So, can we proceed, sir?
Yes.
I think that application NDPS, is this what you're talking about? Section 2. So it's not very clearly said, but
It is a schedule, ma'am.
no, I don't understand.
So they are something else.
What is it that NDPS is doing?
And this is NDPS.
No. You said that in SADA, if there is any question, then NDPS has
So,
to. Right? That is
Okay.
What is that?
I have gone just after the completion is concerned. Because I have to find out. Otherwise, I will explain. Like section 51, as per section 15, wherever where we have any confusion regarding search, seizure, arrest, we must follow CRPC or BNSS. So same way. Like 53 and from SADA it is 27. 53 and 27 of SADA, both are same, giving power of a investigating officer, the power of a station house officer of the police station. Police to take we are moving fast because many topics are left. Section BNSS 47 we all know, ground of arrest. Before I think 2020, in the arrest memo it is also written on which ground the person is being arrested. But now Supreme Court is asking to give separate form of ground of arrest. On which ground the person has been arrested. So we are now in this format.
If not given, then release him on bail immediately. Now given their
Right.
gives
Right.
judgment. If ground of arrest is not mentioned,
So I have taken out this section and
Not
included my slide.
mention, then the magistrate should also check. If magistrate now this remand order is also not clear, then that is illegal.
Exactly. So I have mentioned this one. Article 22.
Yes.
Report of arrest and seizure.
Yes.
And SADA it is 30
Yes.
and NDPS it is 57. To whom it has to be given? To the immediate superior officer, or from whom he has been given the authority to conduct search, seizure or arrest within 48 hours. 60, 61, 62. 60 means on this provision we seize, confiscate the contraband item along with the expected is what we say, the packaging material and sealing, everything under section 60. The vehicles is seized confiscated under 63 subclause 3, and in SADA it is 32, 33 and 34. 61, the goods which have been used for concealing the contraband item, this is also liable for confiscating.
That's politics. all this is a procedure without any consent. How can they protect this?
Sir, this is the procedure after conclusion of the trial.
Even
It is a process of post-trial, means once the accused is acquitted and convicted, and it is proved that the vehicle was used in the drug trafficking, then it will be confiscated. Otherwise, the judge has all the power.
no fault, I want to honor.
No, if it is proved in the trial that vehicle has been used,
He is so everything to
Okay.
take the vehicle that we use for the transporting.
Right.
Now, I am because I do not everything.
No, the issue of now vicarious liability has to be considered. He is saying that he is the owner, but this is for
you got my point. You got your point, sir.
that vicarious liability.
In that case, the owner has to pray
Yeah.
before the magistrate that it was what I said. During trial, it must be used that it was first this has been used in the drug trafficking, and second it was of that person, means the person who has been convicted. If the owner is not involved anyway in this case, how the vehicle will be confiscated? It will be returned to him
Yes. That's why
if it is not disposed earlier.
Can we see? No, this is not the issue. The issue is now it's not so easy. How to now this make it simple to understand is when owner engage the driver and that particular act was done during the course of the employment, then the vicariously owner will be liable. Owner can't say I don't know, I am innocent, because during the course of the
Exactly.
employment that has been done.
It has to be proved
Yeah.
beyond all reasonable doubt.
Yes.
Once the person is acquitted, the accused person has been acquitted, then it is okay. The vehicle will be released straight away. If the person is convicted, then it becomes very difficult for the owner of the vehicle also to prove that this vehicle was not used with his intention. Otherwise, if it is proved that the involvement of the vehicle owner is not directly in this present case, then it can be released to that person.
possibly to what you call it is got to the honor.
Exactly.
Is concerned
It has to be proved during the trial or during the investigation beyond all reasonable
Then
doubt.
the procedure to appoint lawyer on behalf of owner also will be proceeding of the criminal case. So if owner interest is agreed, let the procedure is another counsel. Simply for protecting vehicle.
So interesting, sir. And sir, this is the same proceeding that we have seen. And next, sir, this is another topic that I wanted to discuss here. Nowadays, you are seeing the drug traffickers are getting richer day by day because the margin of the drugs are so high. One example I give you, sir. I was posted in Manipur. There is one tablet, Yaba. You have seen or not, I don't know. It's pink color tablets, a small tablet, and stimulant category of stimulant. Means one or two tablet if you consume, you could just sing and dance and whatever you want to do throughout the night without getting tired. You can do anything. It means gives you so much energy. Energy it's not giving actually. It speeds up the metabolism rate in your body. That releases the energy in quicker way. That is done with that tablet. And what happens? Now when the effects of the tablet gets normalized, the person starts collapse. He just gets collapsed. So that is the price of the tablet there is only 70-80 rupees. And it comes directly from Myanmar, crossing all Myanmar porous border. And once it reaches to Guwahati, price becomes 300 to 400. And it in the daily,
Enjoying the trip, but actually tolerate also
once it crosses 2 or 3 state boundaries, the price is very much higher. So in Delhi, the price of the same tablet becomes 1,000 for one tablet. So you just see the margin. Now what happens? The drug users or the who are involved in commercial quantity trafficking, they are earning lot of money, and they are earning money and they are just concealing the money in so many other forms. in bank balance, in purchasing of the plot, properties, immovable properties, car, costly.
Then I have a cases of type of person because mafia is a person, but direct there is no involvement direct. He everything on delivering, but all the money transaction through digitized system, and even he used to give the scooty bike or battery to the college student and money back when they are taking everything. When the police started investigating, already they gone to the source of the house, he shocked the house and vehicles, almost all vehicles 50, 60, 80 lakhs, and there are 12, 15 vehicles. Actually,
The actual kingpin is
there is no evidence for this that all the everything will some other person who is keeping ceremony is sitting in this mahal and he will do all the activity in this place.
So the vehicle are in the name of whose?
Others name, some
Relatives or other?
some others name.
But
Even
related-
bike, all relatives, all students, all in by every vehicle, every in the name of some other person. Now even
Sir, you are talking about that Namji case.
yes.
Okay, I heard about that.
One section 1 also.
And I think in that case, one SDP is Navin Roy. Navin Roy. He has frozen the property also
Yes, sir.
in this case. I think this is the only case where financial investigation has been done in Sikkim. The only case. We are talking about that case, sir.
Yes,
Okay. I heard about that case. He's a kingpin in drug trafficking.
somewhere else. Everything. All the money is gone. Is there? I don't know.
Sir,
All the usually
Sir, there is a provision. I don't go on this amendment. We just come on to the procedure. What we can do in Chapter 5A of narcotic drug and psychotropic substance? What are the provisions we have, and what are the tools by which we can freeze or seize the movable or immovable properties or illegally acquired properties of by the accused or his family members. Not only the accused, I will show you the definition of the family as per the Chapter 5A. Who are included in the members of family? These are the steps. First, we have to check the applicability. Who are for whose properties are applicable to be frozen or seized? Identifying the properties. After identification, you have to issue the freezing or seizing order. After issuing a freezing or seizing order, it has to be sent to competent authority. Who will be the competent authority? In India, there are 4 competent authorities in 4 parts: northern, eastern, southern, and western. For all of us, the eastern part, Kolkata, is the nearest competent authority where we have to send the freezing or seizing order. The competent authority gives 30 days time to the party affected. Party affected means the accused person or the person whose property have been taken under the purview of this financial investigation, and the freezing or seizing order has been issued. Thereafter, forfeiture, after 30 days, forfeiture order is passed only after getting or securing the conviction. This is the steps that we follow while issuing freezing or seizing order.
If it is not convicted, acquitted,
Then the properties will be released straight away. There is no.
Also, how
So there is a problem.
these basically drugs cases.
If person is acquitted, how can the property be forfeited or seized?
No. Contraband substances out.
Contraband. I'm not talking about contraband.
other
Properties are illegally acquired properties, movable or immovable properties, like bank balance, land properties, flat, car, these properties. Not the case properties. Okay. Whom this chapter will be applied? A person convicted of an offence not less than 10 years. Means he must be in the category of 10 years or more. Sir, there will be one doubt. Doubt is what? In NDPS case, intermediate quantity, there is punishment varies 1 year to 10 years. But this chapter will not apply there. The category is clearly written for a term of 10 years or more. The category should fall, which means that case must fall in that category. Means the commercial quantity case. Clearly meaning is commercial quantity case. There only we can apply this. Means if the person is caught with intermediate or small quantity, we cannot go for freezing or seizing order. That must be clear. The second thing, a person convicted of a similar kind of offence by a criminal court of competent jurisdiction outside India. If somebody resident of India caught in foreign and similar kind of act, means there must not be NDPS, but there he has similar kind of act and he has been convicted in that act, his property can be forfeited here in India. A person against whom an order of detention order under PIT NDPS Act. Sir, you also knowing about PIT NDPS Act detention order. Once the detention order has been issued, then this chapter will apply to scrutinize the property of the said person. Condition is that detention order should not be revoked on the board, suggestion of the advisory board, or the detention order has not been set aside by the court or the High Court or Supreme Court. This is the condition. This is the category where we follow all the things. And this was included in after 1988, sir. Before that, we only used to do the freezing or confiscation after conviction, securing the conviction. But you know, it takes lot of time, sir. The trial goes on for 5 or 6 years, sometimes 10 years, or 15 years even in a few cases. What happens in that case? The accused and his family members get enough time to dispose of the properties, to conceal the properties, to transfer the properties on somebody else's name. So, for avoiding this provision was added in 1988. Now, just after the arrest of the person, where the minimum, the punishment falling under the category of 10 years or more, we can start proceedings of the chapter 5. Means we can seize or freeze the movable or immovable property or illegally acquired properties. Relative of such persons means not only the accused, sir. If any of his relative, the definition of relative is here. This is the definition of relative. Means let's suppose this is that person. So whose lineal ascendants means his father, grandfather. If the properties are in the name of his father or grandfather, it is also liable for seizing or freezing. Then lineal ascendants, descendants. Now his son, his spouse, son's spouse. Then person's spouse. Means if as a person, his wife, his spouse, and person's brother or sister. Means I cannot take the property in my brother's or sister's name even. His spouse even. Brother, sister's spouse. And then lineal ascendants also. Same way spouse, lineal ascendants, descendants and their spouse. Nothing is left. That is why I asked you whether the property was beyond this definition of the relatives. If it is in the falling in this definition, that must be seized or freezed. This is the definition under chapter 5. And no family member. One is left, sir. One family member is left. You cannot touch the property of that person. Here. If I am that person, my uncle's property will not be under his scrutiny. Just see, it is out of the definition of the family. It is out of the relatives. We have faced this kind of situation, sir. We have intercepted one big kingpin, like you were saying, sir, in Imphal. We simultaneously conducted raid 3 places. We recovered 132 kg of opium, sir, in 2 places, 70 kg and from other places something like that. In 3rd places we could not recover opium, but we recovered 57 point something lakh rupees cash, hard cash. He was the kingpin. Somehow he escaped from the house. We could not apprehend that person. Later on we used this one, financial investigation we initiated. We seized, freeze so many things. His nephew was arrested. From his house we also recovered the contraband of him. Once we have used this freezing order, we issued freezing order. When it came to the office of the competent authority, it was rejected. Just giving the definition, uncle is not falling under the definition of relative. Because nephew's uncle was that who escaped from the house. Only he was left from this definition. Relatives of such person now, after relative, associates of such person. Who will be the associates now? The person who is, let's suppose I have acquired a big house from the drug trafficking. Now I have given 4 or 5 rooms on rent basis and collecting rent from those persons. And now what I have given in the condition, you can stay in my house, but I will purchase some property in your name. But it will, the physical ownership will be with me, but on document the name will be of yours. If such kind of thing has happened, those properties can also be seized on the definition of the associates of such person. If a person is residing in on the rent or in the outhouse of the such persons, his properties, he will be considered as the associates of such person. Present holder of property which was previously held by such persons. Whosoever has taken the properties, but it is in the name of that person, if it is, it can be freezed or seized. Associates who had been or is residing in the residential premises, including outhouse of such persons, who is keeping the affairs of the accounts, means if the CA, chartered accountant of that person, his properties can also be freezed or seized. I am just skipping just emphasizing important points. Any other member, partner or director of the above at the time when such person had been a member, partner or director, means whoever is under the partnership firm or private company under Companies Act 1956, where such person had been or is a member, partner or director. What is illegally acquired properties? Must have been acquired in contravention of any provisions of this Act. Income earning as a derived or obtained from attribute to such contravention.
But how to prove that
Exactly. Now,
the property is benefited property?
sir, there is a formula. Yes, sir. The formula is income is equal to expenditure plus investment plus saving. If your income is equal to this, the sum of these 3 factors, income is equal to expenditure plus investment plus saving. Sir, I was in CBI before that. So while scrutinize the property under disproportionate asset case, DA case, we follow this formula. Means income must be equal to the sum of these 3 factors. Exactly, sir. You just calculate your income, sir. Out of that income you have spent some money. Out of that income you invest something, and out of that income you have some cash in hand or cash at bank, savings. It will never be greater than the incomes, the sum of all the 3. If it is greater than,
Politician at the time of submitting affidavit.
we used to do the same thing, sir. We used to do the same thing. But there is an exception, sir, also. In CBI cases, there is an exception of 20%.
Oh yes.
If it is 20% is above than the income, then it is not undertaken. Means it is not taken as a illegal income. 20%. Okay. If it is more than 20%, then it becomes the DAT, disproportionate asset case. Now, how we calculate this? We calculate like in government employee or salary based person, it is very easy, sir. We just take out the pay slip of in my entire service. It is very much easy.
available, sir. And now, what I have earned, I have either spent or invested in future, like bond or insurance, like PPF or LIC policy, whatsoever. That are all my investment. Out of that income, I have purchased land or expenses are made. I have purchased motor vehicles, jewelry, out of that income. And now what we used to, now the question arises how the kitchen expenses will be calculated, because there is no such book. So in CBI cases, sir, we used to just randomly, it is also, sir, in our SOP also, means in CBI SOP, 33% is calculated as kitchen expenses. Means if you are earning 100 rupees, it will be presumed you are spending 33 rupees on your kitchen expenses.
Based on that kitchen expenses in a member.
Yeah, exactly, sir. For entire family. Yes, sir.
But I am not using. And by the way, some how is calculated?
Sir, that is why 20% is left.
There is one who is
But
provision service rule. In every year they are required to publish the information.
we also do, sir. We have to file immovable property return, IPR.
I have not published anything.
In that case also, sir, your 3 factors will never be greater than your income. And if it is greater than 20% is doable. If you have given the ceiling of 20%, it is doable. But more than that, it means you are earning something which you are hiding. Means illegally you are acquiring something without paying any income tax.
Salary here now in Sikkim, income tax.
Sir, I have also heard that here people are not paying income tax. So that becomes very difficult to calculate on this basis, because what we have the basic means effective tool is ITR, sir, income tax return.
Income tax and return
And-
section 10, subsection 6, triple A,
Sir,
income tax act 1961.
Sikkim state is exempted, I know.
But so far this the government employees is concerned, even if now we are not paying income tax, we are required to file the returns to the department, say that how much property you acquired during this year. There is a provision of punishment also.
Sir,
It also affects.
what I will say, sir, for government employee, if you are not filing ITR, it is also very easy to extract the details of the income, property, everything, sir. Because he is getting the salary now. That is also in his account. That cannot be suppressed or cannot be concealed or cannot be hid. But I am talking about the business person who is not getting a regular salary. There becomes the difficulties for the IU to obtain the actual income from the, because he is not filing the ITR even.
No, they will maintain the
GST returns.
yes GST.
It's for big businessmen, big traders, it is okay. So somehow we have to rely on this formula, some or less, to figure out the income of the illegal income of the accused persons. Because my income is 100 rupees and I cannot purchase the land of 200 rupees. For an example, if I am having throughout my 15 years of service, I have acquired, let's suppose, 1 crore rupees. If I am investing 50 lakh or 60 lakh on purchasing of a particular piece of land, it means that something illegal I am acquiring. So this formula is very effective on calculating the illegally acquired properties, and we follow this one, sir. But we have also effective tools in form of ITR. If the person is not filing ITR, it becomes very easy for us to prove that he is earning illegally acquired properties. He is earning, or if it is filing, if it is not showing that he is paying income tax, that also becomes easy.
They are very smart.
Yeah, yes, I know.
Very
Chartered accountants, sir, we are also smart, sir. Why are you underestimating the potential of IOS, sir?
Yeah.
They are also, agencies are also smart, sir. They are also somehow taking out That is why we, on that, sir, sir, I'm one more, my expressing on this, sir, because being law enforcement agencies, we are not returning to the government much thing. Only we are maintaining this much thing, we are serving. We are taking the salary and we are doing something for government. But this is the way we are returning something in monetary. After seizing and confiscating, we are returning back to government in lieu of our salary. So, in our Union Home Minister also, sir, he has also emphasized much on this one, sir, conducting financial investigation. And we are seizing, freezing in crores of properties, sir. Despite of having chartered accountants and all these things, we are able to get the convictions also. We are able to get the properties seized or freezed. So, this is the competent authority I already said, sir. For we have 4 in India. Who will be the Commissioner of Customs, Income, this one. Customs Commissioner, GST or IT or Officer of equivalent rank of government officers. He will be the competent authority. General rule. Properties cannot be forfeited if required before a period of 6 years. That is the exemption here, sir. Before the 6 years. 6 years on which date? From the date of the arrest, on which date he has been arrested, or on the date on which he has been issued detention order, or the date on which he has been arrested. Whichever the date is there, or even if the arrest authorization has been issued, from that it will be reckoned the properties. That on which a warrant or authorization or arrest has been issued, preventive detention order was issued. Identification. IO has all means to identify, survey, inquiry, by summoning, they can identify the properties, illegally acquired properties. And there is no time limit, sir. For conducting financial investigation, there is no time limit. For one case, multiple freezing or seizing order can also be issued, sir. Once properties has been identified, they have reason to believe, they can issue freezing or seizing order. I am just skipping, sir, because not so important things. After issuing the freezing or seizing order, this competent authority gives 30 days time to the persons affected for and fix a date for hearing. And after hearing, the order gets confirmed. Order gets confirmed. And forfeiture will only take place after conviction.
There is any specific property that can be freeze or seized or anything can be done. Suppose I have done I have arrested properties I have inherited by for my own father and all some person. Can be also.
Yes, sir.
Classification
What we do, sir, if the person is arrested for a case where the minimum punishment is 10 years to 20 years, then we scrutinize his bank balance first. We stop the debit transaction of the bank. So first of all, we do this thing. We stop the, we write the letter to BLN LRO for land revenue officer to extract the details of the immovable properties he has purchased, giving his name, his wife's name, his children's name, or whosoever the family members known to us. We on the name we try to receive the information from the BLN LRO. Then we write to the RTO if we get the details of the vehicles. And now we have one more effective tool, sir. It is called NatGrid. NatGrid. It is given to law enforcement agencies. On giving small information like mobile numbers, Aadhaar or PAN numbers, we get the details of the bank accounts, RTO information, means vehicle registration information, wherever the PAN numbers and Aadhaar cards have been used in purchasing or acquiring those properties. After getting those details, we straightway write to the concerned authorities for stopping the transaction, so that the family members, because most of the cases when the person is arrested, his family member start selling all those properties. If car is there, they will start selling the car through the RTO, means it will be get transferred. So as soon as the person is arrested, without doing much delay, we proceed for the writing to all these concerned authorities. And whoever the family members are, first of all we block the transfer and sale of the properties. Later on, during the investigation, if it is found that property is purchased beyond 6 years, then we release that. But first of all, we stop the transaction, means transfer of the properties.
You can do it before 6 years.
Only 6 years from that day.
10 years.
Cannot be frozen or seized. Cannot be. Or the ancestral properties also. If it is in the name of the person affected, it cannot be freezed or seized. And so, freezing and seizing both can be done, and in one case, several freezing or seizing order can be issued. If the properties are unable to be kept in the possession of the police station or the IO, it is better to always issue the freezing order, not the seizing order. Remain as it is or being used by the family members, but it will be frozen. This is the idea. If the person doesn't appear within the given timeline of 30 days, the ex-party decision is pronounced by the competent authority. Burden of proof always lie with the affected person. Transfer to be null and void. Once the freezing or seizing order has been confirmed, its transfer has been done. If it has been done, it will be null and void. Sir, there is bar of jurisdiction. Bar of jurisdiction. No civil court shall have jurisdiction over matters which tribunal or CA is empowered to determine. Means any aggrieved person from CA, competent authority, he cannot challenge the same in the trial court. It has to be challenged before a appellate tribunal first. There is appellate tribunal is made, and this is that appellate tribunal, sir. And set up by the central government. Chairman and members. Chairman is a sitting or qualifying to be a judge of Supreme Court or High Court. Orders of forfeiture, whatever we are appeal is there, it must be heard before the appellate tribunal instead of any civil court. Chairman shall be person who is always been qualified to be a judge of Supreme Court or High Court. Member not below the rank of Joint Secretary in appellate tribunal. Any aggrieved person, officer mentioned in 60 means if it is rejected, means the order is rejected for confirmation, we can also challenge the same in appellate tribunal. If the party is aggrieved, from our order has been confirmed, he can also visit the challenge the same to appellate tribunal under section 68 code. The bar, no injunction shall be granted by any court or other authority in respect of any action taken or to be taken. No order passed or declaration made shall be appealable except as provided. Means up to High Court it will not be challenged. It has to be challenged first in appellate tribunal, then to Supreme Court. So we just take 10 minutes break, then we conclude for the final session, sir. Because things are there, and if IOs are there, we can take much time. You all know all these things, sir. We're not going through. Just giving you on which theme this judgment is. This is Arif Khan versus State of Uttarakhand, as I was just discussing in my session. It is exclusively for the personal search. It's a landmark judgment, and the rules are currently being applied. No judgment has come to overrule this judgment. So this is the final one, and we are quoting the prosecution, defense are quoting this judgment only. There is an established law. Whenever a personal search is to be conducted, it is as per the guidelines given in Arif Khan. Next, no, remove this.
The topic just
Bharat Ambale versus State of Chhattisgarh. It's a new case, sir. 6 January 2025 only decided, sir, by Supreme Court. Yes. This is for our favor, sir. This only. And it's a new judgment also. 6 January this year only. Bharat Ambale versus State of Chhattisgarh. वो एक डायरेक्टरी है, not mandatory type. E. Michael Ross, you've heard about this. It's old judgment, sir, but very important one. What happened earlier, sir, when the contraband was intercepted? Contraband was intercepted. In this case, what happened? It is a case of NCB, sir. NCB versus this one, E. Michael Ross. And Tamil Nadu NCB actually conducted raids or seizure. 4 kg of heroin was recovered from possession of E. Michael Ross. Everything was proved. Now, when the time came for the judgment or the final argument, the judges took the plea that it is a case of small quantity. How 4 kg is small quantity? They counted the purity. The purity, the official report that came, the purity was only 1 point something %. On calculating of the purity, the contraband becomes 4 kg to 57 gram only. Only the purity content was taken. And this judgment from 2008 until 2020, this prevailed. And many decisions, many cases of NCB and other agencies were just gone in vain. Means it was all came in acquittal only on the basis of E. Michael Raj. Court says why the entire substance will be calculated. The only percentage means if I am a trafficker of heroin, I am taking 1 kg heroin and I am 1 kg of paracetamol powder or talcum powder, I am adding 100 gram of heroin in it. So I must be given punishment of 100 gram of heroin only now. It was the view of the Supreme Court till 2020. And we lost so many cases due to this judgment. Not only NCB, other departments also. No, it's not. Next. Hira Singh. But in 2020, this judgment came. Hira Singh versus Union of India. Again the same case. Now, Supreme Court overruled the previous one judgment of the E. Michael Raj and said it doesn't matter whatever the purity percentage lying with the mixture of the substance. It matters because once I am selling the entire 100 gram and 1 kg of talcum powder, means 1100 gram to the users. Users are not seeing that it is only 100 gram of heroin. They are considering it's 1100 gram of heroin. So you are trafficking of 1100 gram of heroin, not only 100 gram. Because purity is nothing with, it has nothing to do with the abusing or trafficking. It is a matter of FSL and CRCL only. On the basis of this, Hira Singh judgment came and this citation of this E. Michael Rose was overruled. And from 2020, we are all recommending this one, Hira Singh versus Union of India. Very landmark judgment, sir. Very important one. This is the cut means this E. Michael Raj. Sahabuddin versus State of Assam. It's an old one, sir, 2012. But when it was said in the judgment, when large quantity of therapeutical medicines are being trafficked without having any proper valid papers or documentation, it will be presumed that it is for the diversion purposes and for the purpose of trafficking of the drug. From that judgment, thereafter we have started seizing this fentanyl capsicum, sir. Before that, we had no tools for because always the defense used to take the plea that is Schedule H drug, and there is no purview of seizing or seizing of pharmaceutical drug from the NDPS Act. Large quantity means, if in this case what happened, it's a case of Dhubri police.
No, there is NDPS.
In NDPS also, we have small, intermediate and commercial.
Small, intermediate, and
Commercial. Basically, two quantities are given on the list in the schedule, and it is talked about the intermediate quantity. Any quantity falling between small and commercial will be intermediate quantity. There it is large in SADA, in our it is intermediate. And small and commercial are the same. But in your large quantity are very much higher than our intermediate quantity. Means very small, like if you are counting in numbers. If it is 21 capsule, it will be large quantity. And for our, we are weighing this one. If it is like, if it is talked about Yaba tablet, that methamphetamine tablet I was talking about. We have 50 gram, above than 50 gram it is commercial. And here it is 500 capsule, 500 tablets or capsules. So in 50 gram there will be 500. If you weigh 500 capsule or tablets of 500, it will be same like. But in spasmoproxima, or other pills, the quantity is very lesser than our quantity. Your large quantity may be our small quantity. Because we are weighing,
Yes.
and weighing always is lesser than the,
counting is
or you are counting by piece. In capsule you are, how you calculate? Capsule you are counting this much capsules, but we are weighing on the balance.
And how you without plastic or with plastic?
With the plastic, and we write the gross weight, including the weight of the plastic. So, on the basis of that judgment, Sabuddin versus State of Assam, we started seizing fentanyl and codeine-based cough syrup bottles. Mohanlal versus, this is another Mohanlal, sir. There are two Mohanlal. This one is for fair investigation. It was said, informant and investigating officer shall be different persons.
Okay.
In 2018 case. But
There is another factor.
it was overruled.
Overruled.
Overruled by Mukesh Singh.
Oh, yes.
Overruled by Mukesh Singh versus State of NCT Delhi. It was said, it was, since police department has now very much limitation of staff, so there is no any, means there should not be taken any doubt that an informant has done the investigation. Only on the basis of the investigating officers and the informants are same, the prosecution's case cannot be justified as null and void.
Consider this critical.
Yes, other evidences must be there that are leading to acquittal. Mukesh Singh versus State of NCT. Next. State of Rajasthan versus Sairam. Sir, this was came when it was said the entire quantity was not produced before the magistrate. Means by the same. When the trial came, during the trial the entire quantity was not produced. And it was said or it was that
Not produced means?
what
It's an exhibit.
exhibit exactly.
During the trial.
So it was said primary evidence like sample, certified inventory, photographs were already produced before the court. So entire mother seizures are not required to be produced. State of Punjab versus Baljinder Singh. पुराना नहीं है, 7 years से लेकिन ये vehicle search में 50 compliance is not mandatory. Section 50 is exclusively for the personal search. That judgment I was talking about previously. You need not to take the presence of gazetted officer or magistrate during the search of house, vehicle, etc.
No, after this also there is one judgment.
Sir, please.
2009 cases is given.
This is the one, sir. This is the current judgment.
Because I have realized this.
Problem is in the
I am giving all of you, sir. You also go through once. Thana Singh. It's very important landmark judgment, sir. This what happens are there. This accused Thana Singh languished in the jail prison for almost 12 years without having gone the trial. Means after arrest he was languishing in the jail from 12 years. Only date was being adjourned. Adjourned means his date was not being fixed. The trial could not be commenced even up to 12 years. Supreme Court was just amazed to see what is happening here.
I am also shocked.
One of my case in my when I was transported to Nancy, I see the Oxo and SADA case since 2021 is pending. Even some cases, even the charge was not framed, even the Oxo was not examined. So I took out the day-to-day basis 21 years. I have special 21 years like this. All the 21 years I have been.
Supreme Court was so amazed that they straightway first granted the bail to Thana Singh and then passed so many guidelines on this. What are the guidelines, sir? First, the court cannot take unnecessarily adjournments. Second, if
There is no this limit given like CPC.
means without having valid reasons, the court cannot take the adjournments. Court further directed to complete the NDPS cases within 1 year. But you see, sir, kahan ho pa raha hai? But in Thana Singh, it is clearly written that within 1 year, the judgment must be completed. The trial must be completed.
Because the most of the witnesses,
Further,
that's the problem.
they also said, sir, Supreme Court, court must give the block dates. Means if one case, give 3 or 4 dates together, like 11, 12, 13, 14 for one case and complete the entire prosecution in 4 days. Practically not possible, sir, but it was in the guideline of this Thana Singh judgment.
I am sitting court 3, 7, 8 while examining the witnesses.
Exactly, sir.
With 40, 45 witnesses coming every day.
Practically not possible. It's not possible to complete the trial in 1 year, sir. Actually, it's not possible, but further, FSL report, as soon as it is received by the IO, it should be submitted before the court.
Another problem.
It was also directed to FSL also in this case. It provide the report as soon as possible.
You will see these you will comply because 1 lakh now if it is
सर कहाँ कंप्लाई हो पा रहा है? इसके तो बहुत सारे प्रोविजंस हैं. थाना सिंह जजमेंट एक वास्ट जजमेंट है सर. अगर इसका हम लोग कंप्लाई करने जाएंगे तो मुझे लगता है इंडिया में कोई केस पेंडिंग पड़ेगा ही नहीं. कोई पेंडिंग ही नहीं रहेगा. सब विदिन 2 और 3 इयर्स सब कंप्लीट हो जाएगा. कैसे होगा पता नहीं. Union of India versus Kasif. It is also a new judgment, sir. 20 December. It's not very much new, but on the basis of this 50, 40, 42A, all these have been complied by the. It is also a par case, sir, NCB. Okay, sir. High Court granted bail, and the same were challenged in the Supreme Court, and the bail was rejected by the Supreme Court. In this Union of India versus Mohammed Kasif.
so regarding chain of custody,
Sir.
I read somewhere you have been issued blockchain. That particular form blockchain.
Blockchain is not related to this,
I have
sir.
seen I read somewhere blockchain.
Blockchain is
No.
cryptocurrency and darknet.
Not cryptocurrency. They are giving from this blockchain for keeping this chain of custody of the contraband substances. So I read somewhere
Blockchain.
And I was really eager to know this one from blockchain or chain of custody.
Blockchain तो अलग है सर. वो तो हम लोग.
cryptocurrency में है हमारा वो क्या?
हाँ.
When I was actually the
I have also taken class of
Oh,
that cryptocurrency.
cryptocurrency. So the blockchain, that particular issue now they have now taken out from there and using this particular chain of custody of criminal business.
Blockchain. सर काइंडली अगर कुछ हो तो मुझे भी बताइएगा सर. मैंने नहीं सुना है सर.
एक बार सुना मैं भी तो कर यार ऐसे इशू अभी तक मैंने सुना नहीं, ऐसा ये दिल्ली में है या ये एनजीए में ऐसे सुना नहीं। जो मैंने उसके हो रहा था वो निगम समझ गया रिसर्च को सब भाई को क्या जो ज़्यादा बोलते हो बोल के
Business Union of India versus Mohanlal, you all know sir this on sampling, disposal, storage regarding this. So these few important landmark judgments I have taken up, sir. Very helpful.
email ला पढ़ा होता है भाई, email में
So यहीं तक रखते हैं सर.